What do we have today? We have for publication in the United States Court of Appeals for the Ninth Circuit. This is Epic v. Google. This is the Fortnite case. Epic and Apple had it out, and there was sort of a mixed win there. Epic won the right to take payment processing off of Apple's App Store, but Apple won the right or confirmed the right to have a closed app ecosystem. So that was a mixed bag victory there. This is a different victory. So I wanted to go through this today and see what the Ninth Circuit Court of Appeals has confirmed. They sort of tell the whole story from beginning to end. So let's take a look at what the appeals court for the Ninth Circuit has to say. In the world of adrenaline-fueled survival that epitomizes the video game Fortnite, winners are decided in blazes of destruction and glory. By contrast, the outcome of this case, centered on Fortnite's developer Epic Games and the Google Android platform, turns on long-standing principles of trial procedure, antitrust, and injunctive remedies. In 2018, video game developer Epic Games released its immensely popular cross-platform game Fortnite as a smartphone app. For 2 years, Epic sought to distribute the game through direct mobile downloads from its website and through Samsung's Galaxy Store. In 2020, after Epic realized that Google Play was the only hope that Epic had for actually reaching users, Epic reluctantly decided to offer the Fortnite app on both the Google Play Store and the Apple App Store. Fortnite was offered as a free download. The game generates revenue via players' purchase of in-game features. Shortly after Fortnite's launch on the App Store and the Play Store, Epic embedded secret code into the app's software so that players making in-app purchases would bypass the required payment processing systems by which Apple and Google then charged 30% commission. Epic dubbed these circumvention efforts Project Liberty, part of its ongoing and soon highly publicized protest against mainstream app stores' restriction of developers and users' choices for app distribution and in-app billing. Almost immediately, Google and Apple removed Fortnite from the Play Store and App Store for non-compliance with their terms of service. Epic responded by filing antitrust suits. The two suits against Apple and Google proceeded separately. The suit against Apple was resolved in Apple's favor, with Epic receiving the right to tell people via a link or a button or something that they can pay outside the App Store and pay a different rate. Epic's suit against Google followed. After a 15-day trial, 45 witnesses, the jury found that Google had violated federal and state antitrust laws in the markets for Android app distribution and in-app billing services. The district court held extensive post-trial proceedings and then entered a permanent injunction against Google to restore market competition. We affirm the jury's verdict and uphold the district court's injunction. Background. Smartphones have two key components, the physical hardware and the OS. The operating system manages the interaction between the phone's hardware resources and software applications. Google and Apple own two popular operating systems, Android and iOS. These are tied to their hardware. Google's Android system is publicly available for free for anyone to access, modify, or distribute. Google engineered and produced a line of smartphones that run on the Android system, but it licenses Android to hundreds of OEMs that make smartphones. Samsung and Motorola, for example, negotiate licenses to have Android pre-installed onto their products. As a result, Android runs on a variety of smartphones that are not Google brand devices. Apps are offered and installed separately from the operating system, but an app can only be installed on a device if it is compatible. iOS apps only work with iPhones that run iOS. Android only works with Android. The applicable operating system creates an ecosystem of app development, distribution, maintenance, and security. Google, in addition to owning and primarily developing the Android operating system, owns the Play Store, a platform for distributing apps to Android users. The Play Store has an enormous catalog of more than 2 million apps. In two-sided markets like this one, where Android users and Android app developers, the two sides, rely on the platform as an intermediary for user-developer transactions, the platform benefits from significant network effects, where the value of the services that a two-sided platform provides increases as the number of participants on both sides increase. Users are attracted to large catalogs and developers are attracted to large user bases. Google magnified these network effects and entrenched its dominant position in Android app distribution by its intentional efforts to frustrate users' access to and use of alternatives to the Play Store, such as developer websites or competing Android app stores. Although an Android app developer can enable potential users to download its apps directly from a developer-specific website, direct downloading or sideloading, Google's operating system creates friction that deters Android users from completing downloads this way. First, the default settings disable direct downloading. Users savvy enough to change the default settings must then click through a series of scare screens, sometimes as many as 14, to complete a direct download. Some of these screens notified the user that the app was being downloaded from an unknown source, that the software could harm their device, that the user was taking responsibility for damage that might result. Android's scare screens do not reflect any security assessment of the intended download sources. These screens appear whether the download source is a trusted developer's website or a hypothetical I'llStealYourInfo.com. The scare screens operate as a deterrent to downloading apps other than directly from the Play Store. Efforts to download Fortnite illustrate the practical import of barriers erected by Google. Android users had to successfully navigate more than 15 steps to complete a direct download of Fortnite. Such friction degraded the quality of the download experience from websites like Epic's. Epic found that, of the Android users who initiated the process to download Fortnite directly, 35% abandoned the process after encountering Google's warning messages. In its dealings with OEMs, Google also sought to obstruct access to alternative app stores. Google's mobile contract, the Mobile Application Distribution Agreement, effectively required Android OEMs to pre-install the Play Store on the default home screen of their smartphones. Google's revenue-sharing agreements with the premier tier of these OEMs had the added effect of making the Play Store the only pre-installed app store on their phones. And Google's proposal to Samsung, denominated Project Banyan, would have compensated an especially formidable OEM app distribution competitor to drive down its app distribution market share and turn the Galaxy Store into a throughway for Play Store traffic. Samsung's representatives expressly understood that the purpose of Project Banyan was to prevent unnecessary competition with the store. We want competition. Competition's good. That's the free market. As Epic's expert testified about these revenue-sharing arrangements, these provisions, this conduct, disincentivizes OEMs from competing with the Play Store. When Epic suddenly posed a threat to the Play Store's dominance, Google went further still. In 2018, Epic initially told Google that it would not be introducing an Android version of Fortnite on the Play Store. Google feared that the game's off-play launch could legitimize another Android app store and create a contagion, leading other software developers to leave the Play Store. To defend against that scenario, Google initiated Project Hug, a series of special agreements with the top 22 game developers, including Activision, under which developers received cash payments and other benefits to not launch on any Android app store other than the Play Store. Network effects, default settings, and scare screens to deter direct downloads, plus strategic deals to limit the use of alternate stores, proved a potent cocktail. As of 2020, the Play Store accounted for 95% of Android app downloads and more than 80% around the world, excluding China. Google leveraged its significant market share in app distribution to maximize its profits from the Play Store. All developers offering apps on the Play Store are required by a developer distribution agreement to process in-app purchases using Google Play billing and pay a hefty commission on nearly all in-app transactions. As of 2021, the Play Store was turning a 71% operating profit. Convinced that Google was abusing its power, Epic sued Google shortly after Fortnite was removed from the Play Store for the alleged violations of, it was removed for violations of the contract. The lawsuit was for violations under the Sherman Antitrust Act, the California Cartwright Act, California Unfair Competition Law, and Google counterclaimed for a breach of contract. Additional claimants sued Google for antitrust. All these related claims were consolidated into a single multi-district litigation. In 2021, the district court decided that all jury triable issues common to the parties' legal and equitable claims would be decided by a single jury trial. In April 2023, the court set November 2023 trial date. April and November. Before then, every plaintiff other than Epic settled, leaving the trial only on Epic's antitrust claims. December 11th, a jury returned a unanimous verdict in favor of Epic. On the antitrust claims, the jury found that Epic had proven the relevant product markets for Android app distribution and billing and a relevant geographic market, and the jury found that Google violated both the federal and the California antitrust laws by willfully acquiring or maintaining monopoly power in those markets, unreasonably restraining trade, and unlawfully tying use of the Play Store to Google Play billing. Although Google's counterclaims for damages initially were part of the trial, the parties withdrew those claims and later settled them. Remedies proceedings followed the trial with extensive briefing. The district court entered a permanent injunction and an explanatory order. The 3-year injunction prohibits Google from providing certain benefits to app distributors, OEMs, or developers, or carriers in exchange for advantaging the Play Store. It mandates that Google allow developers offering apps on the Play Store to provide users with information about access to alternate app billing, pricing, and distribution. Apropos of the claims, the injunction includes catalog sharing and app distribution provisions. The first requires that Google permit third-party Android app stores to access the Google Play Store's catalog of apps. And the second requires Google to allow the distribution of third-party app distribution platforms or stores through the Google Play Store. Google was given 8 months to comply with the catalog sharing and app store distribution requirements. To review and resolve any issues that arose, the injunction also directed a 3-person technical committee to review it, I guess. On Google's claim, which we reject, that the decision in Epic v. Apple precludes Epic from defining the market differently here, we move to the jury issues, confirming the district court did not abuse its discretion on Epic's equitable claims and Google's damages claims. Finally, we affirm the district court's injunction, which was supported by the jury's verdict, as well as the district court's own findings. So first, we're going to skip this part. The Epic v. Apple litigation does not change anything about this case. We're just going to skip ahead. Apparently the difference, Apple does not license its operating system to other OEMs. That's the main difference. Okay, here's the permanent injunction and the injunction's provisions. Following the jury's verdict, the district court commenced post-trial proceedings that allowed each side a virtually unlimited opportunity to present its views about the scope and content of an injunction. Epic submitted a proposed injunction, Google objected, the court extensively queried both parties and their many fact and expert witnesses. After 2 evidentiary hearings, 20 written submissions from the parties, vigorous argument by counsel, the court finally entered a permanent injunction and issued findings of fact and conclusions of law. The injunction balances Epic's proposals to remedy the antitrust violations against Google's concerns about overbreadth security and implementation. Adopting a nationwide scope and halving, as in cutting it in half, Epic's proposed 6-year timeline to a 3-year timeline, the injunction commenced November 1st, 2024. The court's order began by prohibiting anti-competitive arrangements that insulate the Play Store and Play billing from competition. The injunction prohibits Google from sharing Play Store revenue with actual or prospective entrants in the Android app distribution market, just as Google earlier sought to compensate Samsung with Project Banyan to prevent unnecessary competition. The injunction next prohibits Google from engaging counterparties in restrictive deals that condition payment or access to the Play Store on 1, an agreement to launch apps first or exclusively on the Play Store, or 2, an agreement to pre-install the Play Store and not any other app store in a specific location on an Android smartphone. Finally, the injunction prohibits Google from continuing to require Google Play billing for all apps distributed on the Play Store. The district court explained that these remedies closely track the evidence of anti-competitive conduct at trial. On appeal, Google does not directly challenge these prohibitions on anti-competitive arrangements, though it folds them into its broader attacks on the factual findings and Epic's standing to seek a nationwide injunction. In addition to these restrictions on Google's prior conduct, the injunction also seeks to restore competition in the Android app distribution market with the catalog access and app store distribution remedies. The catalog access remedy requires Google to permit third-party Android app stores to access the Play Store's catalog of apps, so that competing app stores can offer users a comparable library of software products. On the other side of the market, the App Store distribution remedy forbids Google from banning third-party Android app distribution platforms or stores through the Google Play Store, so that these same platforms can access Android smartphone users who are currently accustomed to downloading all their apps through the Play Store. Together, these provisions allow other app stores to compete in this two-sided market by letting them offer the apps and reach the users on the Play Store platform. The district court gave Google an 8-month timeline to develop the systems needed to comply with both the catalog access and app store distribution remedies. Responding to Google's concerns about the safety of products offered on the Play Store, the injunction permits Google to adopt reasonable measures and to charge a reasonable fee based on Google's actual costs to ensure users' security and privacy. Finally, anticipating disputes over implementation, the court ordered the formation of a 3-person technical committee composed of 1 member selected by Epic, another by Google, and a third selected by both. We uphold the injunction in full. We begin with the catalog access approach to restoring competition. We agree with the FTC and the DOJ that our review must account for the particular characteristics of digital markets which can allow monopolists that achieved or maintained dominance through exclusionary conduct to perpetuate entry barriers and maintain monopoly power long after that conduct has stopped. Given these realities, we recognize the district court's large discretion to meet the special needs of the case, which must include the nature of the market. The district court repeatedly emphasized that the catalog access remedy is intended to ameliorate the consequences intertwined with the network effects that Google has enjoyed as a monopolist in a two-sided platform market. Specifically, the court cited evidence about the Play Store's advantaged position between a critical mass of app developers and a critical mass of app users, quoting directly from Google's internal presentations that users come to the Play Store because we have by far the most compelling catalog of apps and games. Developers come to Play because that's where the users are, and even formidable competitors like Amazon will struggle to break those network effects. The district court explained, and the catalog access remedy seeks to overcome the Play Store's illegally amplified network effects by giving rival stores a fair opportunity to establish themselves with a competitive catalog of software applications. The provision temporarily opens up the Android app distribution market by giving app stores a 3-year window to access the singular catalog that Google accumulated and leveraged during the Play Store's dominance of the market. As the district court put it, all that the catalog access provision does is level the playing field for a discrete period of time so that the rival app stores have a fighting chance to get off the ground. Google objects on the grounds that it illegally imposes a duty-to-deal requirement, and it imposes that requirement without identifying a causal connection. The district court replies that it is not true that courts cannot and have never compelled antitrust defendants to deal with rivals. Google's reliance on the Trinco decision is inept. That case addressed the question of whether a unilateral refusal to deal with rivals, not the legality of compelling a defendant, was legal. Google tries to differentiate by claiming the district court improperly ordered Google to design new products, which no one agrees that it was required to design new products. Google is not being asked to develop a new product or service from scratch. Google complains a lot. It also objects the causal connection was not clearly defined. Google highlights its first mover status in the Android app distribution market to claim that some of the Play Store's network effects must owe to the lawful advantage, that they were the first mover and the best producer in the market. First, initial innovation notwithstanding, a first mover is not entitled to maintain and magnify the relevant network effects by entrenching its dominance through anti-competitive conduct. Second, Google misconstrues the responsibility of the district court which was not obligated to ensure only that conduct enjoined or mandated by the catalog access provision had a significant causal connection to the violation found, the district court fulfilled that obligation when it stated the question is whether Google engaged in anti-competitive conduct that had the consequence of entrenching and maintaining its monopoly power in a two-sided market. The jury answered that question in the affirmative. On App Store distribution, the district court's injunction also restricts Google from prohibiting the distribution of third-party Android app distribution platforms through the Google Play Store. Google is still entitled to charge a reasonable fee for security and safety. Google raises the same challenges. The district court exceeded its authority and failed to make a causal finding. The district court, however, laid bare how market entrants faced hurdles on both ends of the two-sided market for Android app distribution. The yin and yang of this symbiotic relationship locked other App Store users out of the Play Store, while app developers and users were locked in. Google knew that competitors would struggle not just because their catalog of apps and games is very limited, but because they don't have users. The explanatory order put it, the App Store distribution provision lowers the barriers for rival app stores to get onto users' phones by enjoining Google from prohibiting the presence of rival app stores on the Google Play Store. The district court acted within its discretion to mandate a reasonable fee and chose the right price level to ensure pro-competition of the App Store distribution remedy. Again, we emphasize the district court conducted extensive proceedings before issuing the injunction and the accompanying order. The court gave the parties ample opportunity to state and refine their positions. The court reviewed Google's blunderbuss of comments and complaints in 90-plus pages of objections. We pay heed to all this evidence and the district court's proximity to it. Google also can't win on unduly burdensome contractual restrictions. Again, they complain that the district court failed to explain why it did not adopt certain modifications to the contract that Google asked for. Just because Google didn't get something that it proposed has no basis to upend the injunction. And then they challenged Epic's standing. You can always challenge standing, so you can challenge it even at the end of the case, basically saying that Epic didn't have standing. Standing is the requirement that you have a dog in the fight, that you have that you've been injured, you went to purchase something on the App Store, you went to release something on the App Store, and you were affected by it, the antitrust behavior. The ultimate scope of an injunction is reviewed for abuse of discretion and is based on the merits, not redressability. To the extent that Google challenges the district court's exercise of discretion in crafting the injunction, we disagree. The nationwide prohibitions fit squarely within the district court's large discretion to craft equitable antitrust remedies. These remedies and their scope are supported by the record and the nature of the market, and we uphold them, along with the liability verdict and the entire injunction affirmed. Yeah, so that's pretty remarkable. The difference between the Epic versus Apple and Epic v. Google case seems to be that Apple doesn't license its products for outsiders, so therefore Apple is allowed to maintain the closed ecosystem so long as it maintains the closed ecosystem. Because Google doesn't maintain a closed ecosystem, then they have market competition and are not allowed to behave in certain ways that are considered by modern civilization to be anti-competitive. Yeah, sure, you can vacuum up all of the resources for something and then charge everybody any price that you want. That doesn't mean that you're a intelligent capitalist, and not in modern operations of capitalism. That's one of the more broken problems with pure capitalism, that eventually that's what happens. Eventually, the stakeholders, the people who have ownership of the markets will eventually become too large. So you need to have free competition. You need to have free market. And the free market requires regulation, which doesn't sound very capitalistic. So it's a kind of a conundrum. That's one of the problems we have in our modern societies these days. So Google, because they open their ecosystem, they have to fully open their ecosystem, fully in the sense of being compliant with antitrust law. They wouldn't normally have to open their app store to competitors. They wouldn't normally have to help the competition, but they have hurt the competition illegally for so long that now the judge has said the competitors get a little bit of an advantage for 3 years so that they can sort of get themselves kickstarted and maybe have a chance of survival. Anyway, let me know what you think in the comments below. I am looking forward to seeing some changes to the Google Play Store, and I'm curious what effect it will have on Google's dominance in the market. That's all I have for you today, so have a great day, have a great week, and I love you all. I'll see you in the videos that drop. I'm Leonard French, your favorite copyright attorney.